Alright, I got this lawsuit response here from Gold Weems, and they have answered kind of in general how I've made my accusations in general. I find it interesting that they want to say that the library is called the Natchitoches Parish Government, which, I mean, there's either Natchitoches Parish, they have a council, the Natchitoches Parish Council, or they have the Natchitoches City Government. But from what I understand, it's the library is the Natchitoches Parish Library, so it's the county. But they hired Goldweems, and Goldweems works for the city and the and the county here as well, because when I file FOIA requests directly through the city, Goldweems will respond. So they don't just work for the county; they work for the city. They work for the entire government structure of Natchitoches, pretty much, and they work out of Alexandria. So I copied um, what I could from ChatGPT of the response, and ChatGPT has reworded it, so I might have to go through this again. But there's several defenses. Okay, we'll start with the first one. First defense: the plaintiff's petition fails to state a cause of action upon which relief can be granted. Okay, um, and that's strange. It almost seems like just kind of a blanket statement because I'm asking for the lifetime ban to be lifted. I don't understand. Plaintiff's petition fails to state a cause of action upon which relief can be granted. Second defense. Now these defenses I think might be um, in order from my accusations on my lawsuit. I have to double check that. I just got this evening. Second defense: the defendant denies it owes, and the defendant's the library, denies it owed or assumed a duty to plaintiff, to me, if a duty existed, that it breached any such duty. Okay. Second defense: the defendant denies owing or assuming any duty to the plaintiff. Alternatively, if a duty existed, the defendant denies breaching it. Okay, third defense: the defendant denies that its actions were the legal or proximate cause of the injuries or damages alleged. It also denies the scope of any duty owed encompassed the risk alleged to have resulted in the alleged injuries or damages. Okay, that was third. The defendant denies its actions were the legal or proximate cause of the injuries or damages alleged. It denied the scope of any duty owed encompassed the risk alleged to have resulted in injuries or damages. Okay, fourth defense. The defendant pleads the following non-exclusive limitations and defenses under the revised statutes: immunity for policy making or discretionary acts. There's statutes here. Limiting liability of boards, commissions, and authorities. Immunity for policy making or discretionary acts or omissions. Limiting liability to intoxicated plaintiffs. Okay. Limiting. So he's just kind of throwing that out there that I could have been drunk at the time. Limiting care and custody immunity. Limiting liability to felonious plaintiffs if I had a felony. Limitations on court costs. Limitations on venue. Limitations on damage awards. Limitations on collection of judgments and settlements, limitations on court costs and legal interests, prohibiting suits against interlocal risk pools. Yeah, they're just throwing everything out there. Political subdivision. Okay, and that was fourth defense. Okay, the defendant invokes several non-exclusive statutory limitations and defenses under the Louisiana revised statutes. Immunity for policy making, limited liability of boards, commissions, and authorities, immunity for policy making or discretionary acts or omissions, limiting liability to intoxicated plaintiffs, limiting care and custody immunity, limiting liability to felonious plaintiffs, limitations on court costs, limitations on venue, limitations on damage awards, limitations on the collection of judgments and settlements. Okay. And then more about court costs, prohibiting suits against interlocal risk pools, political subdivision immunity, relevant statutes are applicable. So I'm not too familiar with these limiting statutes. I'll have to look at. Fifth defense, the library asserts all affirmative defenses under Article 1005 of the Louisiana Code of Civil Procedure and any other recognized affirmative defenses, including aggressor doctrine, emergency doctrine, lack of mitigation of damages, absolute discretionary and or qualified immunity, good faith, estoppel, public duty doctrine. Okay, we got more. Okay, that's fifth defense. Let me just go back here. Defendant specifically avers any and all affirmative defenses enumerated in Article 1005 of the Louisiana Code of Civil Procedure, which are applicable to this case and any and all other affirmative defenses recognized by this jurisprudence, and these are pled herein as if copied in extenso, including but not limited to aggressor doctrine, emergency doctrine, lack of mitigation of damages, absolute discretionary and or qualified immunity, good faith, estoppel, they just put good faith twice, and public duty doctrine. Alright, sixth defense. The plaintiff is not entitled to present evidence of any alleged damages not disclosed before trial and supported by evidence produced through discovery. Alright, the sixth defense. Plaintiff is barred from presenting evidence of damages not disclosed before trial or supported by discovery. Yeah, we haven't gone into discovery yet. Seventh defense. The defendant denies liability. See, that's what I needed to have ChatGPT do, is to change the wording, change defendant to library. The library denies liability. However, if liability is determined, any damage award to the plaintiff must be offset by the plaintiff's fault and failure to mitigate damages. In the alternative, and only in the event it is determined any defendant is liable for any library, if the library is liable for any claim asserted herein, which liability is expressly denied, any damage award to plaintiffs, which damages are also expressly denied, should be offset by my guilt and failure to mitigate my damages. Eighth defense. The library specifically avers that I should not recover for any payments, injuries, or damages which resulted from pre-existing or subsequent conditions and which were not proximately caused by the accidents described in the petition. Defendant or the library cannot be held liable for such damages to the extent they were sustained in other incidents. Okay, that's 8. The defendant asserts that the damages resulting from pre-existing or subsequent conditions not caused by the described accident cannot be recovered. Okay, ninth defense. The plaintiff's participation and consent in the actions, or my participation and consent in actions leading to alleged injury or damage invalidate the claims. That's ninth. I knowingly participated in those actions which I claim to have caused injury or damage. Since such participation and consent were given knowingly and voluntarily, my claims are invalid. 10th defense. Any damages I claim to have suffered were caused or made worse by an event that occurred before or after the accident described in the petition. Alright, before or after, not during. The damages claimed were caused or worsened by events unrelated to the described accident. Alright, 11th. That was 10. 11. The defendant, the library claims that any damages alleged in the petition were caused by the negligence or fault of me and or third parties, not the library. And or third parties. Defendant avers any damages alleged in the petition were caused by the negligence and or fault of the plaintiff and or third parties, not the library. 12th offense. If I sustained any damages in the manner alleged in the petition, which the library specifically denies, such damages were caused partially or solely by the negligence of me, whose negligence should bar or reduce any recovery against the library. Okay, and that was that 12? 12. Alright, if I sustain any damages, the library denies responsibility. Such damages were caused wholly or partially by my negligence, which should bar or reduce recovery against the library. The library raises the dilatory exception of vagueness and ambiguity on the 13th defense. Defendant asserts the dilatory exception of vagueness and ambiguity. Okay, that's exact. 14th defense. The library did not violate any constitutional rights of the plaintiff, and all actions of the library was objectively reasonable considering established law. Okay, and that was the 14th defense. The library asserts that it did not violate any constitutional rights of me, and all actions taken were objectively reasonable under established law. 15th defense. The library asserts that at all times it acted in good faith and conducted itself reasonably under the circumstances. Alright, at all times the library acted in good faith and conducted itself. Okay, we got that exact. 16th defense. The library affirmatively asserts the defense of waiver by plaintiff. Okay, that's exact. 17th defense. The library claims the plaintiff's suit is frivolous and seeks to recover attorney fees, expert costs, and other costs incurred in defending the lawsuit. The library avers that my suit is frivolous, thus entitling the library to recover its attorney fees, expert costs, and costs incurred in defense of my lawsuit. 18th defense. The library is entitled to absolute immunity under Bogan v. Scott Harris. Alright, that's not going to be explained. I have to read that one. Absolute immunity for the library. 19th defense. The defendant or the library argues that punitive damages may not be awarded against a governmental entity or an official acting in their official capacity. Further, the plaintiff has not provided a basis under Louisiana law to support a claim for punitive damages. That's 19th defense. Defendant avers, the library avers that punitive damages may not be awarded against a governmental entity or governmental actor in its official capacity. Further, I have failed to state any basis under Louisiana law for the award of punitive damages against the library. 20 defense. The library avers that attorney fees may not be awarded because I am not represented by an attorney. Let's see. That was 19th. The library argues that punitive damages may not be awarded against a governmental entity or an official acting. Okay. 20th. The defendant argues that attorney fees may not be awarded because a plaintiff is not. Okay. 21st defense. The library reserves the right to assert additional defenses if warranted by discovery. Additionally, the library requests a jury trial in this matter. Didn't I request a jury trial? I have to look at my lawsuit. Okay. It's 21st defense. The library reserves the right to assert additional defenses if discovery shows additional defenses are warranted. The library is entitled to and hereby request a trial by jury in this matter. And now for the answers to the petition-specific allegations. The library states, let's see, let me just get down to that. Responses to specific allegations. Paragraph 1. The library states that this paragraph is a recitation of my identity and does not require a response. To the extent a response is necessary, the library denies any liability in paragraph 1. Paragraph 1 of the petition constitutes merely a recitation of the named plaintiff and requires no response. Okay. Paragraph 2 constitutes merely a recitation. They just repeat themselves there. Okay, let's skip to paragraph 3. It constitutes a collection of legal conclusions and thus requires no response from the library to the extent any response could be necessary. The library denies any liability whatsoever to the plaintiff. I'm sure it's going to say that for 3. The library claims this paragraph contains legal conclusions that require no response. Paragraph 4, similar to paragraph 3. Okay. Alright, paragraph 5. The library denies this paragraph as written, but admits that I entered the library on or about January 22nd. All other allegations in this paragraph are denied. Okay. Okay, paragraph 7 is admitted. Okay, we got a paragraph 7 that's admitted. No liability is admitted. Okay, paragraph 8 is denied for lack of sufficient information to justify a belief therein. Further answering upon information and belief, police officers observed pornography on plaintiff's computer. That's 8. Let's see. Paragraph 8 is denied for lack of sufficient information to justify a belief therein. Additionally, the library asserts that upon information and belief, police officers observe pornography on the plaintiff's computer. Okay. Paragraph 9 is denied for lack of sufficient information. Okay, alright. So lack of sufficient information, we go through a lot of that because they're going paragraph by paragraph for my lawsuit. Okay, they acknowledge things. Okay, just straight denied. And we go through paragraph by paragraph. They number them. So the entirety of the wherefore paragraph of the petition is denied. Okay. Defendant states that any allegations not specifically addressed above is denied. Okay, wherefore the library prays this answer and affirmative defenses be deemed good and sufficient, and after due proceedings, judgment be rendered in the defendant's favor and against me, dismissing my demands with prejudice. The library further prays that I be found liable for paying the defendant's or the library's costs and attorney fees arising from association with my filing of this lawsuit and the library's defense of the same. Okay, we're skipping through all these paragraphs because I asked ChatGPT to like read this verbatim, and it summarizes regardless. The library prays that the answer be deemed sufficient and valid, that the judgment be rendered in the library's favor and against me, dismissing all of my claims with prejudice, that the library be found liable for that I have to pay the library's costs for attorney fees, because the library wants a jury trial for this.